Order. Nous sommes le Subcommittee des droits internationaux.
We are the Subcommittee on International Human Rights, a subcommittee of the Standing Committee on Foreign Affairs. This is meeting number 10 that is taking place today.
Very cooperative in departing. Now, I appreciate that these proceedings are televised. And I was told that some of the folks who are taking still photos will stay for a couple of minutes and then we'll depart. If they could do so in the least intrusive way possible, I would be most grateful. We have today with us, and we give our thanks to Lieutenant Commander William Keebler. I will just briefly say that Lieutenant Commander Keebler is the military counsel to Omar Khadr in his proceedings before the military tribunal. He has an impressive record in his own right, including the ultimate signal of importance in the early 21st century, which is his own article on Wikipedia. And if you want to know more about him, you can go there rather than listening to me. He's joined today by Rebecca Snyder, who is Mr. Khadr's civilian counsel at the Office of the Chief Defense Counsel at the Office of Military Commissions. Welcome to both of our witnesses today. We have our own rules of engagement today, which were agreed to by the committee at our meeting yesterday. The questions and answers will be 5 minutes rather than the normal 7. That's to allow, hopefully, us to complete a first round and get at least partway through a second round of questions. We'll continue our questioning until shortly before 2. Because of the fact that I'm cutting the questions quite short, I want to ensure that Lieutenant Commander Keebler is able to respond in a general sense to questions that may have been in the generality of the specific questions being asked. Then we can wrap up at 2. If there is a consensus, we can go beyond, but it's worth considering the fact that individuals here will want to be able to speak to the media at the end of this hearing, and doing that and making it to question period in time might make it impossible to go beyond 2. Be aware of the fact that I will be responsive to the will of the committee as to the time for adjournment. With that being said, Lieutenant Commander, I wonder if we could turn things over to you.
Thank you. First of all, let me begin by thanking the members of the subcommittee, Mr. Chairman, for having me here today to address this very important issue. I have a brief prepared statement, and then I will take any questions that the members of the subcommittee have. The last citizen of a Western nation to be detained at the Guantanamo Bay Naval Station is 21-year-old Canadian Omar Khadr. I represent Omar in military commission and related proceedings in the courts of the United States. I must preface my remarks by stating that I speak today as Omar Khadr's U.S. military lawyer. My views do not represent the official views of the Department of Defense or the U.S. government. A poll released just last week indicates that the overwhelming majority of Canadians believe that Omar will not receive a fair trial from a Guantanamo Bay military commission. They are correct. A majority of those prepared to offer an opinion support Omar's return to Canada to face justice under Canadian law. Yet there are some who clearly understand the injustice being done to Omar and view it as such, who are unsure. I believe their hesitation to be motivated by concerns about whether Omar, however unjustly he may have been treated in the past, will pose a threat to the safety and security of Canadians if and when he returns. I want to spend the next few moments addressing those concerns. Such concerns are understandable. Understandable in light of the deplorable and offensive behavior of certain members of the Khadr family. Understandable in light of the lies that have been told about Omar and his actions in the July 2002 firefight in Afghanistan. And understandable in light of Canadians' justifiable anger with the actions of Omar's father. First, Canadians are right to be offended by the public comments of Maha and Zainab Khadr. I am familiar with their remarks that impugn Canadian values and express sympathy for our common enemies. As a U.S. naval officer, I am as disturbed by them as anyone in this room. Indeed, probably more so, because I blame the extremist tendencies they represent for much, if not most, of the harm that has befallen my young client. Thankfully, Maha and Zainab Khater do not speak for Omar. I do. Second, Canadians would be right to be afraid of the Omar Khater who has been falsely described by the U.S. government and the media over the past few years. In a largely fictitious story, first told by the Department of Defense in 2002, Omar was the lone survivor of a 4-hour bombardment of an al-Qaeda compound near coast Afghanistan. The story was that he waited in the rubble and then rose up, wielding a pistol and hand grenade, taking a group of U.S. soldiers by surprise and killing a medic before being shot in the chest. No part of this story is true, however, and the Omar Khater it describes does not exist. The real picture of Omar Khater, which has been revealed in the last few months as the contents of U.S. government documents have been disclosed for the first time, is that of a frightened, wounded, 15-year-old boy. A boy, like other children wrongfully involved in armed conflict, who had no business being there, who sat slumped against a bush while a battle raged around him. Omar was then shot in the back, at least twice, by a U.S. soldier, and was then about to be executed when another soldier intervened. Conveniently blamed for the unfortunate death of Sergeant Christopher Spear, official records were retroactively altered so that Omar could be held responsible. And this, the real Omar Khater, has thus languished, almost forgotten, in Guantanamo Bay and exploited as a source of information about his father and family for nearly 6 years. Third, Canadians are right to be angry with Omar's father, Ahmed Saeed Khater. Whatever his connections to or affiliations with al-Qaeda, clearly he bears the ultimate blame for turning his back on Canada, depriving Omar of his birthright as a Canadian citizen by taking him away from this country, and putting his children, including Omar, in harm's way. But Ahmed Khater is dead, and the son should not go on being punished for the sins of the father. Omar views himself as a victim of decisions made for him by his family. Omar Khater did not choose to go into combat as a 15-year-old child soldier in Afghanistan. Like other child soldiers, he was put there. And what the U.S. government has thus consistently failed to take into account in its treatment of Omar is that if all it alleges is true, Omar is not one of our enemies in the war on terror. He is a fellow victim of those enemies. International law concerning the protection of child soldiers, law in whose development Canada has taken a leading role, is consistent with this view. The Convention on the Rights of the Child's optional protocol on the involvement of children in armed conflict, known as the Child Soldier Protocol, establishes the minimum age at which a person can be deemed to voluntarily participate in armed conflict, both for state armed forces and non-state armed groups such as al-Qaeda. The protocol requires children who participate in armed conflict to be regarded essentially as victims and afforded opportunities for rehabilitation and reintegration upon capture. It recognizes that the term child soldier is itself an oxymoron. Children are never soldiers. They are children, unlawfully exploited by those who place them in harm's way. But this does not mean that Omar or any other child soldier cannot be held appropriately accountable for criminal conduct. War crimes tribunals convened in Sierra Leone, for example, were authorized to try child soldiers between the ages of 15 and 18, but only in a special chamber staffed by juvenile justice experts in which only rehabilitative rather than punitive sentences could be imposed. This does not describe a Guantanamo Bay military commission. The military commission by which Omar is due to be tried, designed to try people like Khalid Sheikh Mohammed, the alleged mastermind of 9/11, does not take Omar's age into account in any way. Moreover, it does not provide for rehabilitative objectives. This is why it is our view that the U.S. Congress never intended military commissions to try children for war crimes, and that the Pentagon has exceeded its lawful authority in pursuing this case. This is the position put forward in a motion to dismiss the charges pending before the military commission in Guantanamo Bay. Juvenile prosecution or other appropriate proceedings in Canada would, however, be consistent with the protocol. And if Omar is to receive genuine due process at this point, it will only be because Canada follows the lead of the United Kingdom, France, Australia, and every other Western country, and demands Omar's release from Guantanamo Bay to face justice under Canadian law. Justice will not result from a military commission that cannot try U.S. citizens and treats a Canadian as worth less than an American by affording Omar fewer rights and protections than an American would receive. And because Omar is Canadian and detained at Guantanamo Bay, he is denied the access to the regular civilian courts that he would receive if he were a U.S. citizen. Omar identifies himself strongly with Canada. This is a young man who longs to see movies like Lord of the Rings and visit the Canadian Rockies. He is hopeful that he will soon come home to Canada. He knows the obstacles he will face. However, after years of hopelessness, he has begun to allow himself to dream. And they are not the dreams of a dangerous jihadist. They are dreams that we can admire and relate to. The dreams of a young man to get an education, get a job, and begin living, as best he can, the ordinary and normal life of a Canadian citizen. The life that was taken from him when his family moved him from Canada to the Middle East as a child. Omar's story is one of victimization by everyone who has ever had authority over him and punishment for the misdeeds of others. As this subcommittee studies this case and prepares a report recommending appropriate action, please remember two things. Number one, we do not ask for special consideration, only that Omar be afforded the protections guaranteed to child soldiers by the law, protections the U.S. government has failed to afford him. Number two, it's not a question of giving this young man a second chance. He's never had a first one. The only blessing he's had is being born Canadian, and this country now represents his only hope. Thank you, and I'd be happy to take any questions that the members have.
Thank you, Lieutenant Commander. I'll just mention two things before we begin. Number one, I see you've discovered the earpieces, and you might want to notice the volume controls and the fact that you can change channels to get translation from English to French, French to English, or you can have what's called the floor language, simply amplifying the sound of whatever you are receiving. Secondly, although I know you didn't have a prepared presentation, Ms. Snyder, may I assume that you'd be prepared to assist in answering any questions if they come your way? Or would you first? Yes. Okay. Thank you. In that case, we start, Mr. LeBlanc, and I will mention again 5-minute rounds, please.
Thank you, Mr. Chairman, and welcome, Lieutenant Commander and Madame Snyder, to Parliament Hill. Congratulations on the excellent work you're doing in advancing the interests of your client, and in speaking to issues that I think should preoccupy all Canadians, that being the right of Canadian citizenship. And what that means when you're detained in a foreign jurisdiction, and the role that the Government of Canada should be playing in terms of protecting those rights for every Canadian citizen. So for the Liberal Party, thank you for the work you've done and you're doing. We're short of time. My colleague, Mr. Silva, will also want to join in. I have two very specific questions that I'd like to ask. Has the United States detained other child soldiers similar to Omar in the Afghanistan conflict? And has Omar Khadr been treated differently than those other child soldiers? And the second question is, why do you think the Pentagon is so intent on pursuing the case against Mr. Khadr? It seems to us that this has been a high priority case for them that perhaps stands out amongst others. If you have any views on why the Pentagon would be so intent on prosecuting Mr. Khadr.
To answer your first question, the answer to both sub-questions is yes. We know that the U.S. government has detained children in connection with the armed conflict in Afghanistan, both in Afghanistan and at Guantanamo Bay. We don't know, as I sit here, I have no idea what the numbers are in Afghanistan. I think there may be other members or other witnesses that will be testifying before this panel who have extensive experience with child soldier issues, and in particular child soldiers issues in Afghanistan, who can answer that question. But we know that they've detained some number in Afghanistan and probably as many as a dozen in Guantanamo Bay. Although the U.S. government doesn't acknowledge and has not acknowledged that the child soldier protocol in any way affects or should affect the circumstances of detention in Guantanamo Bay, the U.S. government appears to have nonetheless made an effort to comply without acknowledging its obligation. And as a result, a number of the children detained in Guantanamo Bay, to our knowledge, all except Omar, were, during the time of their detention, kept in a separate facility, in other words, segregated from children, kept in a facility known as Camp Iguana. They were afforded special treatment, special access to educational and other rehabilitative services, and eventually repatriated to their home countries from Guantanamo Bay. Omar Khadr, in contrast, has literally from day one, after he was shot by U.S. forces on the battlefield in Afghanistan, been detained as an adult, regardless or without regard to the fact that he was a child under international law and entitled to special protections under the protocol. And so he has been not only has he been detained with adults, but he's been subjected to the same interrogation and detention regime that adult detainees have been subjected to. And so the U.S. government has consistently, in its treatment of Omar, and again, in contrast to other children, failed to comply with the protocol. And of course, the most recent manifestation of that, or the current manifestation of that, is his anticipated trial by military commission. This is a military commission process that does not differentiate at all between children and adults. And so Omar is going to be tried, if he is tried, as an adult on the same terms and under the same procedures that are applied to adult detainees. To answer your second question, and it's interesting to note, while we're on that subject, that obviously Omar's case is, and I'll talk about this in a moment, obviously Omar's case is somewhat notorious in that he's alleged to have killed a U.S. soldier in the course of hostilities in Afghanistan. I think it's worth noting that one of the first, if not the first, U.S. soldiers killed in the course of the Afghan conflict was a man by the name of Nathan Chapman, who was shot by a 14-year-old Afghani boy who was detained by the U.S. for some period of time, and then, again, consistent with the protocol, ultimately released and reintegrated into Afghan society. So, again, the point is that the U.S. has made some effort to comply with respect to other children. With respect to your second question, my own view, if you go back to November 2005, and it's important to keep in mind when we're talking about military commissions that there have been 3 versions of this process since 9/11. 2 versions under a presidential executive order, and then after the Supreme Court struck down military commissions under the authority of that executive order as a violation of the Geneva Conventions, another system, the current system, that's authorized by statute. So Omar was one of the detainees charged in the first military commission system, and at that time, the so-called high-value detainees, the Khalid Sheikh Mohammeds, the other alleged 9/11 conspirators, were in secret detention someplace. They weren't in Guantanamo. They probably weren't going to be in Guantanamo for some period of time. And so all of the detainees who could potentially be charged by the United States were these low-level people. And I think if you sort of put 2 and 2 together, that the chief prosecutor at the time looked at the allegations in Omar's case, the fact that he was, he allegedly killed a soldier, that there was a real victim, that there was a family and so forth, and looked at this case as really one that might have more media appeal and might serve to publicly legitimate the military commissions process when compared with the other prospective defendants. And so what we find is that Omar was charged initially in November 2005, and that the majority of the actual investigation that has revealed the defects that have come to light in the last several months was conducted after that initial charging decision. So I think that explains why he was initially charged, and the fact that the U.S. government is now invested in it because of that decision explains why it goes on.
Thank you. That completes the first question. Madame Barbeau, vous avez la parole.
Oui, merci. Merci, monsieur.
Thank you. Thank you, Lieutenant Commander Kubler. I appreciate your being here today. You know that I'm very concerned myself about the situation of Omar Khadr, this particular case. Do you hear the interpretation? I was saying that I'm very concerned myself about the situation of Omar Khadr. At the present time, I'm a Canadian citizen, but in my childhood, I was born in Haiti, and I found myself in a foreign embassy for a year and 9 months because I was the daughter of a man who was in conflict with the government. I was a young adult at the time. However, I have a young sister who was 8 years old at the time, and for 2 years, this child found herself shut in this embassy where the conditions were no way similar to those experienced by Omar Khadr. I realized this. The only reason being that she was a daughter of someone who was seen as an opponent of the government. And this is why I cannot accept Canada's reaction. We signed the Convention of Geneva that refers to the situation of child soldiers. Child soldiers must be seen as victims, and in my view, Omar Khadr is a victim, and I'm extremely disappointed to see that the Canadian government is not living up to its responsibilities in his respect. These are values that we have recognized through our signature of the Convention, and countries such as Canada and the United States should respect their promises, particularly when we are dealing with children. There is a petition that is being circulated at the present time, a petition that was initiated by the League of Rights and Liberties, calling upon Canadians to signify to their government that they are supporting Mark Khadr and asking him to be brought back to Canada to be brought to justice here. The question I wanted to ask you is, how do you explain the fact that in a conflict such as this, the fact that a group such as Al-Qaeda, we realize that that is not a government group, it did not sign any treaty, how can it, that the Geneva Convention, signatories to the Geneva Convention are not going along with their respects? Is it not true that our reaction as Canadians must be based on our own values, on our own convictions, and not the way in which those we are facing behave? And I would like you to tell us clearly what exactly will happen to Omar Khadr if he is not brought back to Canada. What type of risk is he exposed to?
Thank you for your question. To answer your second question first, understand what the military commission process is designed to do. It is designed to produce criminal convictions using evidence that the United States has gathered through so-called enhanced interrogation techniques in the war on terror. Evidence that does not meet the traditional standards of reliability that we require for criminal prosecutions in the regular courts of the United States or in courts martial for that matter. And so these commissions exist to essentially allow the government to obtain these convictions against this very limited class of defendants using this evidence in the special circumstances of Guantanamo Bay and the war on terror. My belief is that given the nature of these proceedings, given the very prejudicial nature of the evidence that I anticipate will be introduced against Omar at trial, and given the fact that the commission process, again, unlike other juvenile justice proceedings, unlike the Sierra Leone war crimes tribunals, does not take Omar's age into account at all. I believe that he will be convicted, and I believe he will receive an adult sentence. And so even though the evidence is, there's almost no real evidence to support the proposition that Omar actually threw a hand grenade in July 2002 that killed a U.S. soldier. On what we call a principle theory, and I can explain that in some depth or I can't, Omar will probably nonetheless be convicted of murder by a military commission for little more than having survived the firefight. And so given that, and again, given the prejudicial nature of these proceedings, I believe that he will receive a life sentence or something very close to it. As far as your first question, I agree with you entirely. As I said during my remarks, I think what the protocol stands for is the proposition that children who are unlawfully exploited by our enemies and used as tools, really, in combat should be regarded as victims of our enemies and not as part of our enemies. And what's very, very interesting is that the Child Soldier Protocol, the treaty to which the United States and Canada are both parties, and I should point out that Canada was the first country to ratify the protocol. That's how seriously this country takes its commitment to these issues. Essentially recognizes this proposition, and it's very, very up to date. And in fact, the protocol doesn't just address children unlawfully recruited or exploited by state armed forces. It even talks about children unlawfully and exploited and recruited by non-state actors, such as Al-Qaeda. And so it's specifically designed to address the issue before us, which is, in the U.S. government's view, a war with a non-state armed force that has unlawfully recruited and employed a child. And the protocol mandates that Omar Khadr, as such a person, again, be regarded essentially as a victim and afforded opportunities for rehabilitation and recovery. And it's just beyond dispute that the United States government has not complied with the protocol in its treatment of Omar.
Merci, Madame Barbeau. Mr. Marston, please.
Well, thank you, Mr. Chair. As you listen to this story and as it unfolds before us, it's to some extent almost like Omar's paying for the sins of the father. I mean, he must have been a 13, 14-year-old boy when he was taken out of this country, because he was only 15, a 15-year-old boy when he was in the combat. A thing that I came across this weekend that was published in the Hamilton Spectator and also in the Toronto Star, that the former Foreign Affairs Minister Bill Graham says he regrets now not having pushed harder to get young Khadr brought back home. Has this subcommittee's invitation to you been the first and only time or only avenue that you've had to address the situation with the Canadian government?
Yes, with the exception of fairly low-level contacts with the Department of Foreign Affairs to discuss detention issues and other things of a relatively minor nature. We have been unable to obtain an audience with the current government to discuss these matters. But to come back to a point that you made earlier, absolutely, Omar has been punished. I mean, the prosecution against Omar Khadr is essentially an attempt to punish him for the misdeeds of his father. You know, candidly, as somebody who has observed this process over the past year, my belief is that the Canadian public and the Canadian government have been somewhat willing to intervene on his behalf because of the again, very deplorable conduct of his family and some of the statements that they have made, which also constitutes punishment, essentially, for the misdeeds of others. Because again, had they not done those things, I think Canada might be much more proactive in terms of its efforts to help Omar. And then finally, to comment on Mr. Graham's statement, I'm familiar with that interview. I read that, and I appreciate those remarks. I think he notes correctly that yes, it was a different political environment after 9/11. However, it also appears that the Canadian government, and certainly the Canadian public and possibly the Canadian government, was sold a fictitious story, a false bill of goods, about what Omar did in that firefight and the strength of the evidence against him. And we now know, because these documents have come out and the evidence has come to light, that those were misrepresentations upon which this government likely relied to some extent in refraining from being much more aggressive in terms of its protection of Omar's rights. And so whatever transpired in the past, the question from our perspective is, you know, what's the right answer going forward? And now, knowing that evidence is out there and knowing that this military commission process simply does not or cannot be lawfully applied to a minor, it's beyond question that the right answer now is to bring him home to face due process under Canadian law.
Mr. Marston, please.
Well, we've heard other questions talking about the other child soldiers, the ones in Afghanistan, the ones that were held in Guantanamo, and it appears from everything we're hearing that they've all been repatriated to their home countries. And in this case, maybe you've explained it, maybe not quite. Why is Guantanamo Bay, the officials there at the detention center, not provided Omar with the same level of consideration, how he's detained, or in the fact that he has not been repatriated to Canada? Is that because we're not voicing our opinions as a nation strong enough, or is this just part of the case has been tightened in such a way that they can't get out of it themselves?
I think there are two answers to that question. Number one, yes, how you're treated in Guantanamo and ultimately the question of whether or not you leave, the last 5 years have shown, is a function of where you're from and the willingness of your home country to act to protect your rights. Obviously, the story of Guantanamo Bay over the last 5 years is a story of a continuous effort by the political branches to frustrate the ability of the courts to review what's been going on and to enforce the law. And so that has created certainly the situation in which for rights to be protected, it requires the intervention of a foreign government. And there's no question that Canada has not been active, certainly in protecting Omar's rights as a child soldier over the last 5 years. Why has the U.S. government treated him differently? I think, to come back to the theme that we talked about a moment ago, punishment for the sins of others, there's very little question that the U.S. government early on, not so much because of who Omar Khadr was or what he did, but because of who he was related to, saw him as a potentially rich source of intelligence and information about his father and his family and their connections and their contacts. And so apparently a conscious decision was made to treat him as an adult and subject him to the interrogation regime of an adult so that that information could be extracted from him.
All right. Unfortunately, we've just run out of time in this round, Mr. Marsden. I think Mr. Kenny is up next.
Thank you, Mr. Chairman, and thank you, Lieutenant Commander, for taking the time to be with us today. In your testimony, or rather in response to a question just a moment ago, I think you said that the right thing would be for the United States to regard Mr. Khadr as a victim and to focus on his rehabilitation. But in your prepared presentation, you said that if Omar is to receive genuine due process at this point, it can only happen if he faces justice under Canadian law. So if your position is that there's no incriminating evidence and that he should in fact simply be put into a program of rehabilitation, why are you also at the same time suggesting that he could or should face justice under Canadian law? And what would constitute the justice that he would face?
I don't view those two goals as inconsistent. I mean, obviously a prosecution, juvenile justice prosecutions generally, and my understanding in Canada, take place in the light of international law norms concerning, respect of the best interests of the child and so forth. And so a juvenile justice prosecution in Canada would presumably be undertaken with a view towards a rehabilitative sentence or other appropriate sentence given his age at the time of the offenses. And so I don't think that due process or justice under Canadian law is in any way, shape, or form inconsistent with the achievement or attainment of a rehabilitative objective.
But what would be the basis of that due process? Since you say there's no incriminating evidence against him, he didn't commit a crime in Canada, he didn't kill a Canadian abroad, what would trigger any treatment of him under the Canadian judicial system if he were to be transferred here?
What I can say is that there are, in addition to the most serious charge that Omar is facing, the murder charge, there are a number of other charges at issue in the military commission based on other less culpable conduct. And, as Omar Khadr's attorney, it certainly would not be appropriate for me to, point the government in the direction of a way to convict my client of a crime. But what I can say is that, there are certainly other acts, other factual issues that could be the basis for a prosecution. I mean, the larger point is that, I can't offer you a predetermined outcome. Guantanamo Bay does that. What we're asking for is due process. And so if there is evidence that Omar Khadr committed an offense of some kind, whether or not it's murder, and again, I don't believe it is murder, but of some kind, then what we would ask is for Omar to receive the same process that any other Canadian would receive. A prosecutor looks at the file, a prosecutor looks at the evidence, makes a charging decision, a court takes his age and other factors into consideration and arrives at an appropriate sentence. Again, I don't know what the ultimate outcome would be, but we're asking for him to receive the same treatment that any other citizen would receive.
But insofar as it relates to his to the homicide charge that stands against him, do you have any understanding of a basis in Canadian law where the Canadian judicial system could prosecute him for the murder, the alleged murder of an American?
Again, I don't believe that there is evidence to support that charge, and so it would be inappropriate for me to offer an opinion as to whether or not Canadian law would reach the conduct. Again, all I can say is that there is a wealth of information, or there are a wealth of allegations in the charge sheet against Mr. Khadr.
Right.
The Canadian government has a significant amount of information in its possession relating to Mr. Khadr, and so if he engaged in some form of misconduct, it would seem that there would be a basis to prosecute him.
Now, you've drawn certain analogies between his case and those of the child soldiers of Sierra Leone. My understanding from my reading of their situation is that they were generally kidnapped at gunpoint, taken hostage, made to become addicts of hard drugs, and literally forced at gunpoint into military action. Does that fact pattern, is that actually analogous to what preceded Mr. Khadr's presence in the Afghan conflict?
I mean, what I'll say is that certainly Mr. Khadr is not the stereotypical, child soldier from Sierra Leone, for example. But the point is, number one, that the optional protocol, international law, draws a line based on age, on the general theory that children, whatever the source of the coercion, whatever the source of the influence, are less capable of making voluntary choices than are adults.
And does the optional protocol prevent the prosecution of children, of individuals, if they committed their alleged crimes between the ages of 15 and 18?
Not at all. In fact, it's our view that what the optional protocol does require, that in any action taken with respect to a child soldier, that consistent with the general Convention on the Rights of the Child standard of best interest of the child, that any action must be consistent with the best interest of the child and a rehabilitative objective. And so, for example, I point you to the precedent of Sierra Leone, where the prosecution was authorized, even though ultimately no child soldiers were prosecuted, but the prosecution was authorized, but again, only in that special chamber that was juvenile appropriate with rehabilitative objectives. That's not a military commission. A military commission is a one-size-fits-all process.
And is there any requirement under that convention that the country of origin of the person in question seek his penal transfer or judicial transfer? Should he be facing prosecution in another country?
I think there's a general obligation that parties to the convention attempt to ensure that it's respected by other parties to the convention. I mean, I won't get into the fine points of international treaty law, but certainly Canada's leadership on this effort should point it in the direction of seeking to see that it's enforced with respect to one of its own citizens.
Finally, you've said that Mr. Khadr was essentially, I'm paraphrasing, brainwashed by his family and victimized by them, and that essentially that he is a victim. If he's a victim of having been pressed into service as a child soldier, who's guilty and who do you suggest be prosecuted, and under what basis for that crime?
Well, it's interesting you mention this because there's actually a distinct international law-based crime recognized under the Rome Statute for persons who employ as child soldiers persons under the age of 15. Child soldiers between the ages of 15 and 18, even though under the optional protocol they're deemed to be essentially involuntary participants, it does not appear to be a separate crime under international law to employ a child soldier. Now, the protocol does call upon states parties such as Canada and the United States to have national legislation that would make it a crime to employ persons under the age of 18 as soldiers, and I don't know whether Canada has such a statute or such a provision, but without regard to, or without respect to the question of prosecution, clearly his family and ultimately his father should be deemed responsible. Unfortunately, or I should say, his father is dead.
That concludes the time for this round. Mr. Silva, you're up next.
Thank you, and it's a pleasure that you're here before this committee. Just want to state that both the U.S. and Canada, we both have signed and ratified several international conventions. Although we've ratified the International Convention on the Right of the Child, the U.S. has, I believe the U.S. and Somalia are still the only two countries that have not ratified it. But everybody else has, in fact, ratified the two very important conventions. I think one of the most widely signed and ratified convention to date. But it still clearly establishes clear protocols on the rights of children and child soldiers in particular. And there's a whole feeling that in the U.S. there is a little bit both in the terminology and labeling of things, in the way that there's new language has been formulated around the international law of conflicts, of armed conflicts, things like unlawful enemy combatants, which we don't really know what exactly it means. There's all these definitions that are being used by the U.S. To justify their actions and before the legal procedure before the courts, but yet it is outside, one would have to say, outside of the international law and norms that, in fact, have been framed over so many years. So where does the U.S. get sort of this authority to, in fact, impose these types of actions if it is, in fact, outside of international law? And some would argue maybe outside even domestic law as well in the U.S., because the U.S., even if it has not ratified these conventions, has certainly signed many of them, and particularly signed the Convention on the Rights of the Child. So how do you get your legal authority to pursue this if, in fact, you might be operating outside the law?
Well, thank you. I mean, Indeed, there has been much, I think, novel interpretation of the law of armed conflict by the U.S. government over the last 5 years. This concept of unlawful enemy combatant was unknown to the law of armed conflict before 9/11. What I can say generally is that the government's position that a war with Al-Qaeda, that we are at war with Al-Qaeda or went to war with Al-Qaeda after 9/11, seems to have been accepted by the U.S. courts. Contrary to the government's view, the Geneva Conventions do apply to that conflict and provide a minimum standard of protection, even for what the government terms unlawful enemy combatants in that war. There are any number of very complex legal issues raised by both with respect to the U.S. Constitution and with respect to the law of armed conflict raised by the U.S. positions in the war on terror. What I can say to you is that sort of leaving those issues to one side, there is a separate strand of the law of armed conflict, particularly reflected by the optional protocol or the child soldier protocol that I mentioned, that whatever you think of the unlawful enemy combatant concept, whatever you think of some of these novel legal positions that the government has taken to justify aggressive detention and interrogation of people like Khalid Sheikh Mohammed and their trial by military commission, those arguments have no application in the context of a 15-year-old boy who is alleged to have thrown a hand grenade in a firefight, essentially as an act of self-defense. And so what I would say is, all the very difficult rule of law questions that are raised by Guantanamo in the military commissions process are on the one hand, and if Khalid Sheikh Mohammed was a Canadian, this country would have some a very difficult moral dilemma to face, concerning its commitment to the rule of law. But he's not, and you don't. Omar Khadr is a 15-year-old, or was a 15-year-old child, and his rights under international law are very clearly defined and protected, and there is no need for this subcommittee to take on the larger question of Guantanamo Bay and the war on terror in order to recommend that the Canadian government do the right thing with respect to Omar Khadr.
Is Omar the only child soldier in Guantanamo? Is the only one that's there? Was it the only one that's brought there? Do you know?
No, as I said, the other children were detained at Guantanamo. They were detained in a special facility called Camp Iguana and afforded special age-appropriate treatment. Omar appears to have been singled out. There is one other individual whose case is pending before a military commission whose age is not well known. The government says that he was 17 at the time that he engaged in hostilities against the United States, but I don't know that that's been proven as a conclusive matter. And there is some indication that the government charged him for no other reason than to sort of deflect the critique that Omar was being singled out and was the only child soldier being prosecuted by the United States at Guantanamo. So certainly Omar's case and his age being 15 at the time is unique and significant as compared with other children's cases in Guantanamo.
So what will happen to him if he's acquitted? What will the U.S. do with him?
That's interesting because even if he's acquitted, I should say, without regard to whether or not he's tried for an offense, the U.S. government reserves the right to detain Omar as an enemy combatant for the duration of our hostilities with Al-Qaeda, which the government claims are ongoing and there's no end in sight. And so even if Omar is acquitted by a military commission, which won't happen, but even if he is acquitted by a military commission, he remains detained in Guantanamo Bay until this government does something for him. And so it's not a question of trial or no trial. Omar is going to continue to be in Guantanamo Bay until the Canadian people or the Canadian government decides to act to protect his interests.
Thank you.
Thank you. Madame Bachmont, encore?
Si, Monsieur Kibler, vous avez...
Lieutenant Commander Kubler, you mentioned in your presentation that no justice can be given by a political commission that is not entitled to judge a Canadian citizen, and that Omar Khadr is being given a second-class treatment in relation to an American citizen. Can you tell us what the rights and guarantees would be provided to an American citizen in such a context that it would not be enjoyed by Omar Khadr at the present time?
Yes, an American citizen would be entitled to a trial for the let's say the same offenses. An American citizen would be entitled to a trial either in a court-martial for genuine offenses against the law of armed conflict or trial in a federal civilian court in which that citizen would receive all of the rights and protections of the U.S. Constitution. Full confrontation, compulsory process, all the things that a criminal defendant in the United States gets. Moreover, as a juvenile, a U.S. citizen would receive, and first of all, a juvenile would never be tried by a court-martial because of the historical limitations on military jurisdiction to adults, which is part of our argument for why this military commission should not be applied to Omar. But tried in a federal court, a juvenile would receive the protections that all 50 states in the United States afford to juveniles, that Canada affords to juveniles, which is basically a special procedure to determine whether or not he should be tried as an adult, and if not, to be tried as a juvenile, and to be tried as an adult only if that procedure makes that right determination. So any number of protections that Omar would receive if he were an American that he doesn't receive in Guantanamo Bay. He would also, very importantly, receive the right to habeas corpus. And so if he were an American, he would be able to be in front of a federal court today, or more accurately, years ago, to present some of these fundamental challenges to his detention and trial as a child soldier to a regular civilian court without having to go through the process of being tried by a military commission. The U.S. government takes a position, not only are these trials and their procedures limited to non-U.S. citizens, but the U.S. government takes a position that since they occur at Guantanamo Bay, the Constitution, the U.S. Constitution, literally in no way, shape, or form applies to protect these people. And so in Omar's case, what that means, and in the case of other detainees at Guantanamo Bay, they can be tried for offenses that did not become part of the law until literally years after the conduct took place. Omar is being tried for offenses under a statute passed in 2006 for conduct that he allegedly engaged in 2002. And again, the U.S. government says that it can do that to him because he's a Canadian citizen and not a U.S. citizen.
Vous avez encore
Oui. Est-ce que Omar Khadr
I gather that Omar Khadr is being treated as if he were a stateless person. His country of origin is not looking after him. Is there any international legislation that requires, I imagine it probably would be the convention signed by Canada, that would require Canada to take care of its citizens, particularly since we're talking about a child soldier and we are a signatory to this convention? I'd like to know, in your opinion, have you received the appropriate assistance from the Government of Canada in dealing with this? And has Omar Khadr received the assistance that he would be entitled to expect from his country of origin? In such a case, is he not being treated as if he were a stateless person?
Unfortunately, the answer to that last question is yes. I mean, because Canada has not acted to protect his rights are going unprotected in the United States. Whether or not Canada has an international law-based obligation to intervene, I don't know that I will venture an opinion on. Certainly there is some authority. I think in Canada, certainly the United Kingdom, there were suits brought by British detainees against the British government to enforce their rights, or to compel the British government to enforce their rights. And so there may be some authority in the common law tradition for actually requiring the Canadian government to intervene on his behalf. That shouldn't be necessary because it's so obviously the right thing to do. As far as whether or not the Canadian government has assisted, what I will say is this. The Canadian government has taken the position that it wants Omar to receive a fair trial. Yet the Canadian government has numerous documents in its possession related to his case and to his prosecution, documents that may replicate reports generated in 2002 by the U.S. government that have been lost or otherwise gone missing, that could provide an important source of evidence for his defense at trial. Yet the Canadian government, notwithstanding its public protestations, has fought tooth and nail against the disclosure of those very documents that may actually help him in his defense. And so certainly the government's position on that issue has been somewhat inconsistent.
I regret your time is up. This round next includes a conservative, and it's 5 minutes to 2. So here's what I propose. I propose that we allow the conservative round would be Mr. Sweet, and then that the committee agree to allow Mr. Marsden to take the last question. That will take us a little bit past 2 p.m., but I think that's reasonable. Is that agreeable to folks? All right, let's do that then. Mr. Sweet.
Lieutenant Commander Keebler, so in your opinion, what should have happened when Mr. Khadr was originally detained, arrested?
What should have happened is that Omar should have been treated the same way that other children detained by the United States in Afghanistan were treated. He either should have been held in Afghanistan, and I believe that, given his background, it would have been difficult to do this, but repatriated somehow within the context of Afghanistan, or brought to Guantanamo, as other children were, kept in Camp Iguana, afforded access to educational and other rehabilitative services, and then the U.S. government should have made efforts to repatriate him to Canada. Again, at the outset of my remarks, I expressed my condemnation of Maha and Zainab Khater and the remarks that they've made. I think based on their remarks, it would be appropriate for the U.S. government not to want to repatriate him in such a way as that he would fall in line with them and other influences in his immediate family. Yet there are other members of the Khater family that have been known for years that Omar, could have been repatriated successfully too. And then certainly, as with other detainees, the U.S. government could have asked his home government if there were charges that could have been brought in Canada, and he could receive process here. So many options other than the one that had followed, which was to treat him as an adult and eventually seek to try him as an adult for a crime that he probably didn't commit.
Could you tell the committee, how did you come about being the advocate for Mr. Khater? How long have you been the advocate for him? And do you have unfettered access to him?
No one has unfettered access to a client in Guantanamo Bay. It's not like going down to the local jail to see your client if you represent somebody in a regular system. It's a minimum of 2 to 3 weeks lead time. There are a number of restrictions on my ability to visit him that I won't go into in detail here, but I wouldn't call the access unfettered. With that said, I've met with Omar a number of times over the last year. I've spent a number of hours with this young man. I was detailed to the case initially in February 2007. I met with Omar for the first time in June of 2007 and have been his attorney in the military commissions and other proceedings since.
You met with him the first time when?
In June of 2007.
2007. And could you give me more precisely how many hours that you've spent with Mr. Khater?
I would say that we've gone down probably, once a month on average since then. When we go down, we usually spend 2, sometimes 3 days, anywhere from 6 to 8 hours a day with him. So, I don't want to sit here and bore you by doing the math, but that's sort of a rough outline of how much time we spent.
So 20, 30 hours?
No, I'd say more than that.
Pardon me?
I'd say more than that.
More than that? Have you, in the recent legal history, have you seen any parallels to this case at all?
In recent legal history?
Yeah. Any parallels to this case that we're dealing with here with Mr. Khater?
I think the since certainly in the post-World War II history of war crimes tribunals, it is generally unprecedented to prosecute children for war crimes.
Has Mr. Khater had communication with his family back here in Canada?
He's had 2 phone calls in the last 5.5 years.
Just 2 phone calls, that's it?
Yes.
Could you tell me what the status of the various challenges in the Guantanamo process before the U.S. federal courts, what their status is?
There's a case pending in the U.S. Supreme Court, of which we're a part, that is assessing whether or not I referred previously how the Congress had attempted to strip the right of detainees to access the courts through habeas corpus. The constitutionality of those habeas stripping provisions are on review. There is also a case pending, or actually 2 cases pending in the U.S. Court of Appeals for the D.C. Circuit. One is based on an appeal from the Military Appeals Court decision. Again, there are 2 cases pending in the D.C. Circuit concerning Omar.
What about your defense motion?
We have 50-some-odd motions pending or we filed 50-some-odd motions in the Military Commission.
And any idea of when that's going to be heard?
Well, a number of them have been ruled upon already. I mean, the first batch of motions that we filed related to some of the issues that Mr. Silver talked about, the Geneva Conventions and the Constitution, law of armed conflict. Most, if not all, of those motions have been denied with very little analysis by the military judge. Following an argument in which he asked no questions. The child soldier motion, or the motion attacking jurisdiction based on Omar's age at the time of the offenses, is still pending and has not been ruled upon.
Okay, I might be mistaken, but you have a motion to withdraw pending, don't you? Defense
I'm
motion.
sorry?
Don't you have a defense motion? Pardon me?
I think you mean a motion to dismiss.
To dismiss, yes.
Yes, there is a motion to dismiss based on the optional protocol pending before the Military Commission now.
Okay, thank you. And some of us suggested that the trials be moved from Guantanamo to the regular federal court system in the U.S. Give us an idea what that would look like.
I'll speak very briefly because we're actually at the end of the time for this question, but please go ahead.
There has been some discussion of closing down the Guantanamo Bay facility and moving the detainees to Fort Leavenworth or someplace like that for trial by military commission. To my knowledge, that has not moved beyond the discussion stage at this point.
Mr. Marsden, please.
Well, thank you, Mr. Chair. And in Canada these days, we're seeing some of our own military personnel coming back from Afghanistan, some of them with combat stress. And when I consider that this boy of 15 was in a firefight with American Special Forces, he was wounded and nearly executed, I can't imagine what it must have been like for this boy, and I repeat boy quite emphatically, to be taken to Guantanamo to enhanced interrogation. And that's a euphemism today for pretty heavy-duty torture from most people's points of view. And I believe the Canadian government has to recognize Omar Khadr as a child combatant, and they have to do everything they can to have him repatriated to Canada. But the process of repatriation, how would you define that? Is it something that's fairly easy? Is it something very complex? And how important is it for Canada to show leadership in this case?
Well, as I said at the outset, Canada has been a leader in the protection of children in armed conflict and child soldiers in particular, which makes its inaction in Omar's case anomalous, to say the least. What the process of repatriation would look like, we would expect it to look like it has looked in other countries. Canada makes a demand, negotiates terms of the release, and Omar is brought home to Canada to face whatever proceedings are appropriate as determined by the Canadian government under Canadian law. And that is what we believe should happen.
Okay. Was that your only question, Mr. Marsden?
Yes.
In that case, I did suggest that if there were any questions of a general nature that Lieutenant Commander Keebler thought had arisen out of the proceedings, we could give him an opportunity to respond to those. Are there any, Lieutenant Commander?
I just have a couple of remarks in closing, if that's the appropriate time, or
it would be the appropriate time. Do you mind if I just ask a question arising out of Mr. Marsden's question?
Certainly.
He'd indicated that, or he'd asked how the United States, or presumably the relevant personnel in the media or in the military rather would make could be prevailed upon to begin the process of moving Mr. Khadr to Canada, which raises the question, what kind of conditions would they expect? I mean, the intention has been to prosecute him for serious crimes and to lock him away for a very long time. So I assume that they would have a bottom line that's pretty tough. Am I wrong in that regard?
You know, again, there are certainly a number of assumptions that have been made about the nature of the allegations against Omar, the strength of the evidence on the murder charge and so forth that have informed the U.S. government's position thus far. I think in light of the evidence that's come out in the last several months, one would hope that they would be more amenable to a solution or a resolution of the case in light of those revelations. You know, each one of these transfers that have been negotiated from Guantanamo Bay has been a little bit different depending upon the political circumstances and the relationship with the country in question. For the British detainees, for example, the promise was to investigate, to afford due process, basically. And if there was a basis for charges, then the British government would pursue charges. My understanding with respect to the British citizens who were returned to the United Kingdom is that that process resulted in almost immediate release because when they looked at the evidence that was available, there was no basis on which to prosecute. So I don't know that the U.S. government could demand that the Canadian government do anything more than simply follow its law and afford Omar appropriate process under that law.
Right. Obviously, we are constrained at any point by what our law permits. That goes without saying. I thank you then, and I do invite you to please go ahead with your concluding statement.
Well, just briefly to summarize, and again, I've touched on this a few times. 5 years ago, there were assumptions made about who Omar Khadr was and what he did and the strength of the evidence against him. It was clear that he was responsible for throwing a hand grenade in a firefight in Afghanistan because there was one hand grenade and there was one combatant who could have thrown it, namely Omar Khadr. Now we know, based on information that has come to light, largely as a result of investigation that was conducted after the decision to charge Omar was originally made, that not only were there other hand grenades being thrown by both sides in that compound in close proximity, but that there were multiple combatants alive and fighting, and that there really is no real evidence that Omar Khadr was responsible for the death of a U.S. soldier. And indeed, we will never know with complete certainty what happened in the course of that firefight, the same reason that we cannot expect to know what happened in the course of a battle on a foreign battlefield 5, 6, or more years ago. But with all of that said, I want to impress upon the members of the subcommittee that it's not a question of whether Omar is guilty or innocent. This subcommittee is no more the place to try Omar Khadr than the military commission in Guantanamo Bay. Even if he did everything that the U.S. government said he did, what he is guilty of, at worst, is throwing a hand grenade as a soldier in a firefight against people who were trying to kill him. If that happened and it had the unfortunate consequences that it did, then that's a tragedy. However, it is important to recognize that Omar Khadr has spent 5.5 or almost 6 years in some of the most rigorous conditions of confinement imaginable, and has paid whatever penalty, if any is appropriate from that conduct, for that crime. And so as this committee does its work and sits down to evaluate whether or not the U.S. has complied with its obligations under the optional protocol, which we believe it is not, please do not get tied down in the question of whether or not Omar Khadr is innocent or guilty. The answer for Canada today is the same in any event, and that is bring this young man home to face due process in a legitimate system under Canadian law. Thank you.
Thank you to both of our witnesses. Before I gavel the meeting shut, I just want to remind our witnesses that the conclusion of today's proceedings does not terminate their ability to submit any additional documents that may be appropriate as time goes on. Mr. Kenny, please.
Chairman, do you have the revised Zimbabwe motion ready for consideration?
I should ask the clerk that question, but I should advise our witnesses that they're dismissed. We've just moved on to a different piece of business. Do we have
the Zimbabwe motion?
Yeah.
I don't have it with me. I wasn't thinking that the committee would.
The clerk advises me that he doesn't actually have a copy of it. Thank you. Adjourned.